One of the most crucial cases the Constitutional Court judges have ever had to preside over. National Treasury argued that the granting of an interdict to the opposition to Urban Tolling Alliance has serious implications for any future projects.
Are we really going to see a situation where the hospital is built, the whole public structure completed, and what happens is, because there is an almost doctrinal concern with the way funding is to be operated in relation to that hospital, or the way the turnstile works at the Greenpoint Stadium, I reach back and I find underneath, literally, almost literally, underneath the edifice, I find a contendedly reviewable decision.
For its part, SANRAL tried to dispel Oucha's main contention that the decision to introduce e-tolls was unreasonable, as the costs of collection would outstrip the 20 billion rand spent on building the Gauteng freeways.
Whilst in the early phases of the project the costs and the income are more or less comparable, income grows and costs fall over the period.
But Oucha stuck to its guns and tried to convince the Constitutional Court that the decision to introduce e-tolls instead of funding the freeways through the fuel levy was unreasonable.
We would submit that on the facts, and certainly at the interim interdict stage, on all of the factors which we put up in the references which I gave to the court, there's no basis for accepting that a fuel levy is an absolutely and finally excluded alternative.
The hearing was adjourned and judgment reserved. Mbongeni Mucho, SABC News, Johannesburg.